expectations right first. In this live, I will be providing the latest UK visa updates and also provide brief answers to your questions about UK visa applications, EU settlement scheme, British citizenship, etc. I will prioritize in this order: live questions first with priority for channel members questions first, and then the comment sections. Also, I will prioritize members questions first and then the comments of other viewers. uh, Other things to cover: if you stay throughout the live, I will be giving several UKVI updates. There I have some updates on 10-year long residency, settlement scheme, etc. that I will be giving throughout the live in every 10 to 15 minutes or so. And towards the end of the live, I'll be doing this live for about 1 hour 20 minutes to 30 minutes, I think. 1 hour, yeah, about 1.5 hours or so. If you have any live questions, you can ask them. So throughout the live, I will be giving updates every 10-15 minutes or so on any UK visa updates. Secondly, towards the end, I have some things have changed on the 10-year long residence applications. New guidance has been published and statement of changes has been released. I'll cover them. I have some notes over here. I'll also talk about e-visa related issues towards the end of the live, and important update on the costs, fees, etc. from home office. So there are about 3 or 4 different aspects that I will be covering towards the end of the live. So if you stay till towards the end, you'll get information about that. And proof: other viewers have benefited a lot from previous live sessions, have saved costs on immigration advice. If you do like this live, give a thumbs up. If you need immigration advice on your personal issues, hit the link in the description and book the consultation. And yes, to begin with, anyone coming live can ask their questions. And there are no live questions yet. I'll take the questions on the channel for now. If there are any issues with my sound, etc., let me know. I'll move around or change my mic over here. Okay, I have a question on the channel. Hello, my friend is an Indian citizen. He applied EU settlement scheme last year, 2024. Student visa expired. So this is a question where all these buying time applications, which I'm always against about. So yeah, these are the 3 common ones: waivers, FLRs, and this is the new thing that is coming up, this EU settlement scheme. Many agents and all, I don't know which people are doing all this nonsense. They are filing all these EU settlement scheme applications for individuals who are not eligible for that. And this will backfire very badly. I know they've started with the FLR applications, rejecting them. I've made several videos over the last 2 years asking people not to file that FLR just to buy time when you're on a student, skilled worker, or whatever. And you just need, these are not buying time applications. So yes, so FLR is anyways ended. They are picking up them. They are putting people on immigration bail. Everyone is aware of that. So don't do that. Secondly, on fee waiver, yes, they've added one of the things in the guidance. I was just going through the guidance. So the way they are trying to stop the fee waiver abuse is that they've added one liner stating that you can only file. So the way the fee waiver applies is before the end date of your application, you will submit that fee waiver without any fees. It's free. I know many agents, consultants, some lawyers are advising that. Home Office has been fed up of that. I'm a member of Immigration Lawyers Association. I have been on several calls. Managers have told us their queues are just building up. Many of them are frivolous applications, at least 50% of them. Frivolous means where there are no merits of success, such as students, graduate holders, skilled workers, or any PBS migrants filing these applications to buy time. The fee waiver is only for human rights based applications such as spouse visa, parent visa, etc. So anyone other than those who are not under the family route, human rights based applications, it is not for them, and they are abusing the system. So Home Office has come up with a solution. They've put one liner in the guidance, and that's where they will start plugging those applications that I know of. Yeah, it has been recently added. So let's say you file a fee waiver application today. Today is the last date of your permission. you have to tell on the application what I need the favor to make this application, whatever. And graduate route, skilled worker, and all of this will not be on that list. It will be only some human rights based application, parent visa, partner visa, or something like that. So if subsequently, if you don't file that application, so the way people are abusing this is they are filing the application. Whenever it is rejected, within 10 days of that, they file whichever application they want to. By the adding of this extra line in the guidance that the Home Office has done is, you can only file the application that you promised for. So today, if I'm filing a favor, if I don't file the same application, they are going to refuse that, and you won't get even Section 3C. Section 3C falls back on the date of application. It's deemed to be today's date only if you meet the guidance requirements. And the third point which is being added is if you don't file the same application, let's say you file today, you just select, oh, I'm filing spouse visa. Obviously, you're not intending to file that. And whenever that rejection comes, or subsequently, anytime if you try to make a paid application within that 10-day period of the rejection of that application, you have to make only a spouse visa. If you make something else, whatever that is, graduate route, skilled worker, or anything, it will not be accepted. That is what is added in the guidance. That's in simple words. So viewer has been plugged, FLR has been plugged, and now this thing, I think this viewer is asking this. Youth settlement scheme, yeah, that is also abuse of system. His student visa was expiring, and what happened? I'll just read and summarize the facts. Now I know that. Okay, I have a live question. Let me just take that one. I need an advice from my application. For the advice in the description of this video or any other video, there should be a link to book the consultation. It will take you, and you can book the consultation through that. We don't provide any free advice outside of this live. All the advice outside of this live is paid for. So you can click on that link, book the consultation, and take it from there. So Sarpong, thank you for asking live. Okay, so it's a long-winded question, so I'm trying to summarize this one. So I think his student visa was going to end. He or someone filed the EU settlement scheme application last in September, and his student visa. Okay, now I know that he can't get it because he can work for some more months. He has applied for tier 2 visa, so now he's applying for a tier 2 visa. So yeah, the buying time game. Is it possible now he can get the tier 2? It really depends. If his section 3C leave is protected, then he can. And he is also not enrolled his biometrics for his previous application. If you don't enroll, your application is not valid anyways. So if his application, so these are the 2 or 3 possibilities. If he has not enrolled his biometrics and his application is declared invalid, then if for validity you can't even vary it. Yeah, okay. So if he's not enrolled his biometrics, it's difficult for him to vary the application. He won't be able to vary whether it is declared invalid or not. So maybe he should speak to an immigration lawyer and see what his status is. He should have section 3C leave number 1, and he may also have to validate the previous application and then vary it. So there are several steps to be taken. Yeah, speak to an immigration lawyer. You can book a consultation with us or go to any other immigration lawyer. But it's a tricky one. If he doesn't have section 3C, his skilled worker application will not be considered. So Mark Silva, how long does it take for a reply after I submit my argument for spouse visa appeal? Argument for spouse visa appeal. So have you given the skeleton argument to the legal officer of the tribunal who is case building? So after that, can you confirm if you've gone for a paper hearing or oral hearing? I can answer accordingly. So whether you have a paper hearing or an oral hearing at the tribunal. So I think you're talking of the skeleton argument that you have submitted for the spouse visa appeal. First, yeah, just confirm that to me, and then I can give you some idea about it. Mark Silva, okay. Take another question on the channel. This one is done. So next question I have. Kindly clarify 180 days of absence under Tier 2 visa. 180 days is for single vacation in a year, or is it for each time you take in a 12-month period? Yeah, this question keeps on repeating. I've answered this many times. Okay, so for a skilled worker, indefinite leave to remain, or Tier 2, whatever you call it, uh, the absences allowed is up to 180 days in any 12-month cycle, and it's a rolling cycle throughout the 5-year period. So it's not Jan to December, it's every day, you can say, from 1st of Jan to 31st December, from 2nd Jan to 1st of Jan, something like that. So it's a rolling cycle of 12 months. You can be outside the UK for a maximum of 180 days, not more than that. If you are more than that, you break the continuity of residence. It can be in a single vacation, or you can be over 10 different vacations, doesn't matter. So I think you're asking one vacation or several. So is single vacation here, is it for each time? It's a total of each time you go. You can go 10 days, 20 days. It's you have to do a total of all the outside UK days throughout the 12-month rolling cycle for the whole 5 years. So UK re-entry. Next one. If we left the UK, 2 years ban. With the help of voluntary return service, VRS flight ticket support, shall we re-enter after completing 2 years ban? Shall we re-enter? So if you have an eligible application, only then you can apply for it and then re-enter the UK. Yes, if your ban periods have been completed, as per the rules, I think you already know whatever the ban periods are for you. This is from, this is on the comments on the channel, Pops Pappu. So after the ban period, if you are eligible for any application, you can make it. But remember, you will be scrutinized left, right, center on the genuineness. You are trying to file skilled worker student, whatever that is, or even a relationship-based visa. They are going to test everything, all the genuineness. You have overstayed and also gone on public funds. So be careful on that. Take proper advice from a qualified immigration lawyer. So Mark Silva on the live question. I submitted my argument with my supporting documents of 7th of November. 7th of November. Yeah, I think they have to give some time. So I think you have not answered whether it is a paper or oral hearing. But anyways, the legal officer of the tribunals, they will give some time to Home Office to submit their side of the documents. You have given your skeleton argument, giving whatever are the points in dispute. Home Office will file their side, and that's how they will build up the case. Once that is built up, after that it will be submitted to the judge. So it will take a lot of time. I think I have submitted several skeleton appeals. We have done at least 2 months, yeah, at least 3 months we are waiting, 2 to 3 months, approximately 3 months or so on several of them. So Home Office does take time, so the legal officer will just keep on extending their time. Usually they will give some more time or something, but then how long does it take to get a reply? Yeah, you won't get a reply if you are expecting you're building up the case after that. So the steps would be, the Home Office will be given time to submit their side. Legal officer builds up the case. Any discrepancies, they will write back to either parties, Home Office or you, ask you to provide any other things, and then it will go to the judge. If it's a paper hearing, it will go, paper hearing may come, yeah, quickly, but then we usually do oral hearings only. So after that, maybe 3 to 6 months, the case should be listed once the case is built by the legal officer of the tribunal. But then it's just 7th November, so maybe at least 3 months or so, approximately 2 to 3 months, for them to reply, the court officer, legal officer. Okay, next. Okay, no live questions. Thank you, Mark. Thank you. Okay, next question I have about, anyone coming live can ask their questions. How much is it? 10 minutes. Okay, maybe I will consider giving some update. Let us see, what do I have? E-visa updates. So if you're uploading, so Usually most of the people who have BRPs, they create the e-visa with a BRP, and after that, usually since their BRP is expired already, they may be, so the Home Office requires you to update your passport as the identification document to access your e-visa. If anyone who has done that and they file a subsequent application, then there is some system issue going on where the ID check app is not helping out, it's not going forward, and it cannot be done. Thank you very much, Mark Silva, for your super chat. I don't know what is that. I think it is a super chat. Thank you very much. Thank you for that. Okay. Uh, yeah, if you do, anyone who's getting any value from this live, you can consider becoming a member of the channel. There are some nominal fees, I think 2 or 3 pounds or something, and you get some additional features or whatever YouTube calls it. So there are, I think, 2 levels of membership. You can check on the channel information. You can consider supporting the channel in that way, get some videos, early access, and yeah, so there are some perks over there. Just consider becoming a member if you are getting value from here. So the update here is, so if you've already updated your passport, so first you created your visa with your BRP, and then you're updated your passport as the identification document, then you can only access your e-visa through that passport information. One problem that is coming up, there's a system issue that has been raised with Home Office. They are trying to sort it out. If you try to file another application, let's say you are making another skilled worker application, any application for that matter, if you try to use it through the app, it doesn't go through. You have to do the normal application process and the appointment process. So this is just an update. If you are intending to file an application in the next 3 months or so, Home Office, I don't think they will come up with a fix very quickly. They are trying to fix it. But if you are trying to come up with a you're trying to file any application inside the UK and your intention is to file using the app without going for a biometric, don't update your passport. Yeah, and the second thing is, assuming you don't have any travel plans till that date, because if you travel then you may have to update your passport. So yeah, don't update your passport if you don't have any travel plans and have an application um, very near in the future, say about 2 to 3 months. Keep accessing it through that BRP only, even if it is expired. Yeah. So that is one thing that I would recommend. Um, okay, that is the update, and I will go on to the Q&A again. No live questions yet. So let us see which one. Okay, so the next question I have is reuse on the video of English test certificate for extension or renewal. Hi, is it okay if I use the B1 test that's from outside UK to do FLRM extension? My first FLRM used A1 test from my country when I did the fiance visa 2 years ago. I'll be traveling back to my country soon and think to take B1 test there at British Council. Yeah, so this is possible. That's not a problem. You can give the test, even your subsequent tests. So the question is, the person is already in the UK on a partner or spouse visa. He or she has to give the B1 test now. I think they have passed A1 previously, and for the extension of the application, the intention is to pass B1, so he can use it at the extension and for the ILR also, even if it is expired. That's how reuse of English test applies. So hello Babakar, good morning. Yes, thank you for joining. Thank you for becoming a member. I see you are a member for a long time. Yeah. If you have any questions, I know you'll be asking about parent visa. And remember that. If you have any questions, ask me. No updates on the timelines. Okay, yet. Sorry. So the next one is, okay. So you can give the English test anywhere. Even if you're filing extension inside UK or an ILR in the UK, you can use those tests. The test has a reference number. For example, if you give a test in the UK with Trinity College, it will be TCL and it starts a long reference. Home Office has an interface where they can put that reference and check if it is genuine or not. In the same way, if you are going back to your home country, in this Ellen Wang's situation, she's going back, she is going back to the home country and is asking whether she can give the B1 test over there. You can give the B1 test anywhere, provided it is one of those approved providers. If it is IELTS, I think you are giving with British Council. I know it is IELTS, so it will have that reference number IEL beginning with IEL. So Home Office can verify it. You can give your test outside the UK, not an issue. That's fine. Yeah. Okay, next question, Naveen Malik. Good morning. I'm leaving my current job on 31st Jan. I've got my skilled worker visa. Okay. Visa approved for new job, and I will join in April. Okay, April. I want to go home during these 2 months. Interesting. Yeah, these situations. Yeah, you already approved one. You didn't start the work. There should not be any issue traveling outside the UK, but the only thing is you have not started your work. Let me think. So, what would be my position if I go outside the UK and then I'm coming back? What permission am I coming on? On the current one? Yes, on the current one, because no, it depends on me to accept which permission I want to take. Let me think through it just 1 minute. Yeah, it is possible, I know, but what is the best approach? Let me think that. You're living current on 31st of Jan. I've got my skilled worker visa. Okay, so anyways, you ended. They will report it. So your new visa is what you are entering on. Skilled worker visa job. I will join a job in April. In these 2 months. Yes, it is possible. I know that. I know I have advised several clients in the past on this. We've discussed in the lawyer community also about this. Uh, it's about the timelines and how to approach it. Speak to an immigration lawyer. I know it is possible. I can say a yes, but it's a qualified yes. And you get all further facts, and I can advise if me or any other immigration lawyer speak to them and take proper advice. But it is possible. I know that. I need to the exact work end dates when the company is reporting the start date. What about the new company? Are they happy to prepone your start date or whatever that is? I need to understand all the facts properly. Also, yeah, even the job codes, and also home office behaves differently on different job codes while entering the UK. So it is possible. That's a qualified yes, but it is possible. I know that 100% because you have a valid permission. You can leave. You can come back to the UK. It is possible. But yeah, speak to an immigration lawyer to get a proper exhaustive step-by-step advice. Either you can book a consultation with us, the link should be in the description, or speak to any other immigration lawyer. But it is possible. I know people have done this in the past. I have advised on these matters. Yes, Naveen. Okay. So the next question on the channel, unlocking UK visa for viewers. Okay. So next question I have is, good day. I deeply admire your knowledge. Okay, thank you. When I received, I only got the sticker, not the decision letter. Notice the dates are wrong. Okay. You are on healthcare visa and work in the NHS. Yeah, overall speaking, yes, it may be possible. You should be able to travel in and out. But to get a proper advice, yeah, so I'm not giving immigration advice over here. I'm just trying to answer from past experiences and home office approach. But in your case, yeah, speak to an immigration lawyer. That's my advice. It is possible. That's the only yes and no I can give. So in this question, Priya Chawla, so what has happened? So she applied for an entry clearance. I don't know which permission it is, but yeah, she got a vignette starting from 18 Jan 2026. That's interesting. And her student course is starting in this Jan. Very interesting. And the mistake. Okay, so this is a situation where the student has applied from outside UK. On the arrival date question, she has put 2026 instead of 2025. The home office, whoever the department, did not look at it carefully, and they also gave her from 2026. Rather, her course is starting from now, 2025. It's a difficult one. You may, but then, yeah. So you are asking, do you need a new CAS and apply again? That would be the recommended advice. That would be the best practice. Like that's how you're going as per the immigration rules. If you get a new CAS, apply again, and then yeah, you get a new CAS, apply again, put the correct dates, and then you can get a new sticker if you have time. That's what you're recommending. But then if there are any issues, you may lose the previous fees. Yeah, you may lose the previous fees, and the IH is also quite a tricky one with all that. But yeah, if that is one of the things you're considering, that's fine. But then there may be channels to even rectify this, what has happened. Yeah, speak to an immigration lawyer if the current situation needs to be rectified. It's not just your mistake, it's also home office mistake. They never looked at it. The course is this year. No doubt you said by mistake that you want to come back come next year. and home office did not override that. They should have overridden it and written back to you saying which start date you want. Well, what is your date of arrival? You've given it 2026. Can you please check and let us know? uh, or they should have given it from a reasonable date this year. So my advice is, yeah, speak to an immigration lawyer and see if that can be rectified. We need to know all the facts of the case, and there may be a possibility of rectification. 50-50 chances, I think, but because there is a lot of costs and all involved if you go through a new application and all. So no more live questions yet. So speak to an immigration lawyer, book a consultation with us, or speak to any qualified immigration lawyer. That's my advice on that one. So next question I have: incorrect visa vignette pasted in the passport by QVI. Okay, I think that is the same question. Okay, let's take next one. Next question on Home Office and email cause is not valid. Could you please tell me how to resolve this? Cause is not valid. Yeah, they may have checked in the system and only then they will reply saying cause is not valid. So either your sponsor has withdrawn that cause, or it is it's just a fraudulent cause. Maybe I have an issue with my visa. Could you please clarify? Okay, so if they have said cause is not valid, go back to your employer, ask them why the cause is not valid. They have to go and check on the system. The cause should be live on the system. If it is not for whatever reasons, then the cause is not valid. I don't know what is the problem. There may be n number of issues with that, but you need to speak to your employer, get a new cause, whatever the issue is with that cause. Yeah, home office will not just send you something saying cause is not valid. They may have put the cause reference and seen it on the system. So go back to your employer with this problem. Ask them why the home office is saying the cause is not valid. Have you given some fraudulent cause to me, or have you withdrawn the cause? What is the issue? They need to go and check in the sponsor management system and see what is happening over there. And the employers can contact the business help desk and see if something is wrong, if they think they have done everything right, and still the home office is saying this. Next question I have is how many photos? Okay, how many chats we need? So this is the question on UK spouse visa or partner visa. So there is a video of photos and pictures. How I think I have made how many you need to give to the home office. So the 88 Invisible is asking how many chats we need. How many chats? The way we always focus is you look back last 2 years. If your relationship has been less than 2 years, from that point, whichever point your relationship started, if your relationship has been, you both have been in a relationship for at least the last 2 years or more, then cover minimum last 2 years. Chats, if let's say you are talking of WhatsApp chat, there is a way to send the chat history to yourself. If you Google search for how to send my chat history, even on Android phones or Apple, you can do that. You will get the steps on Google how to send my chat history, and a text file is sent to you usually. uh, in that text file you can select one page every month, one page, so maybe 24 pages or so approximately. Not a very strong or a hard and fast number. You can use between 20 and 30 pages, but this is what we usually ask, maybe at least one page every month, to show continuity of relationship throughout the 2 year period at least. Or let's say you are showing relationship of 1 year, then throughout the 1 year give at least one page for every month. That is how we put it. So that WhatsApp chat will send you like a very big file. It may have 500 pages, text pages. It's a text file, so, or 1,000, but you don't have to send all of that. Just select any one page every month, and to show continuity of relationship. Also, the types of chat that you want to show is where you are doing a day-to-day thing. So if you are showing a genuine relationship, or you are living together, let's say you are sending, we are out of milk, can you buy milk on the way home? So this is what they want to see. They don't want to see, they want to see what happens in a relationship normally. So they don't want to say good morning in the morning and I love you, and at the end of the day, thank you, bye bye, good night, I love you. So this is what home office has told us in several meetings when we asked them. We want to see how a usual couple would talk to each other on a day-to-day basis. Yeah, so that is the type of chat you should produce. Okay, so next question I have is, can I apply for a 5 year skill? Okay, we are currently A large number of cases waiting to process, we understand. Okay, this question is about voluntary return service. So I think Muazzam, Muazzam has asked, I think you applied for the voluntary return service. I'm not sure why you are applying to the voluntary return service. If you already have your passport and you want to leave the UK, you should straight away buy the ticket and leave the UK. That's my advice. If you want to keep your immigration history reasonable and good. If you don't have your passport, only then you go to the VR voluntary return service. Uh, yeah, I think I'm assuming you don't have your passport. That's the reason you are applying to the VRS voluntary return service to get your passport at the airport and leave the UK. So you've applied to them and they said they have a large number of cases. Usually within a week or so they do reply. I think you got a standard reply saying we are currently have a large number of cases waiting to be processed and etc etc, and it is in the queue and it will be progressed. Usually VRS, usually they do progress quickly within a week or so. I think they should come back to you 1 week or 2 weeks on a higher end. You can also call them. You should have that number on your refusal letter or Google search for phone number for voluntary return service UK. You should get that just to follow up if you wish to. That is a department that will just take your e-ticket. They will ask you to send your e-ticket, send your passport to the airport, and when you go to the airport, when you go through the security and all, I think at that point they give you the passport. Yeah, something like that, to make sure that you are leaving the UK. Okay. Okay, so next question I have is, anyone coming live can ask their questions. This live will be saved on the channel, so from the comment section I'm answering whatever I can and you can watch in your own time. uh, so the next question is, my wife received from home office demand for demand settlement. This question is on EU settlement scheme, settled status, I'm assuming. So Sarah, the viewer says, my wife received from home office for demand settlement. I don't understand demand settlement, but my wife, we are leaving, I think living, you mean Paris with my kids. She's French national. We have not enough document right now. I can't apply settlement. Okay, so you got that home office automated email saying apply for settlement if you qualify. It's just an automated email. It goes to everyone. Yeah, so it will be finished next year. I have no also end of document that will be going on, please. Yeah, so I think the situation is the couple are living outside the UK. One is a EU national, the other is a non-EU national, or whatever that is. They have some pre-settled status. Home office automated email has gone to them saying file for settled status if you are eligible and you are worried. Yeah, so if you never want to come back to the UK, just ignore that. Doesn't matter, your pre-settled status will lapse anyway. uh, and if you lived outside the UK continuously for a period of 2 years, yeah, I think it is increasing to 3, but not in the news. Yeah, so at least for 2 years, then your pre-settled status may have lapsed anyways. If you're intending to file, I'm not sure how long you've spent outside the UK, or you're coming in and out, or you want to come back, speak to an immigration lawyer, get the information, get proper advice on it if you are planning to apply for the settled status for either of you. If you don't plan to come back to the UK, don't want to file anything, just ignore that email. Pre-settled status will lapse anyways. So that is my advice. You can book a consultation with us or speak to any other immigration lawyer. Babakar, yes, hi, how are you? Sir, on the parent visa, British child, will the Home Office contact the GP to see if I attend appointments? I don't think they do contact the GPs, but please do ask the GP only to confirm what has been done. So if you're not attending the appointments, then ask them. I don't think they should write that. But then the best practice is just go with the child and attend the appointments. Yeah, it's good practice. You will build up a relationship with the child. I have young children, so yes, I do go to doctors and dentists and all. Last week I took them to the dentist. So yes, that's my advice. Take them, and they are not going to call the GPs. I've not seen that, but yeah, do it anyways. It will help you with your bonding with your children, with your child. Okay, so Hero While, good morning. I'm currently on graduate visa. I have visa until November 2025. Got skilled worker visa under new entrant. Okay, February. Wait until, let me just move my. Okay, so I'm currently on graduate visa. Visa until 25 November. Okay, I got skilled visa. Okay, visa under category new entrant. On February, can I get a new entrant visa for 2 years and 6 months or only 2 years? From the graduate switching, yeah, in your case, it may have been 2 years and 6 months. So the way it operates is the total of graduate route permission plus the skilled worker new entrant permission can be maximum 4 years. So if you fully exhaust your graduate route permission in the last month when you apply, you will only get 2 years of new entrant skilled worker. Some people halfway through their graduate route, let's say after 1 year, 1.5 year on graduate route, they will apply for switching. In that case, they can get the remaining period. So 4 years minus the time spent on graduate route. That is the equation. Yes. So you will get the new entrant permission. That is how I would put it. Uh, 4 years you can get a new entrant skilled worker permission when you're switching from graduate to that category. The formula would be 4 years minus the time already spent on the graduate route. That is the period you can get. It can be 4.5 years, it can be 4 years and 5 years also. It can be, sorry, 2 years plus 6 months, 2 years and 6 months, or 2 years and 3 years also, depending on how much time you have spent on the graduate route. So the total permission, graduate plus skilled worker new entrant, can be 4 years. So let's say if you already spent 1 year on graduate route, then you switch, then you can get up to 3 years of up to 2 years of new entrant, four, yeah, up to 3 years of new entrant. Sorry, I'm not sure if you understood, but I tried to explain. uh, so 4 is the maximum graduate plus skilled worker new entrant. जमीन पटेल सर, मुझे इमिग्रेशन बिल 201 आया है, तो मैं क्या कर सकता हूँ? मैं रिपोर्टिंग किया हूँ एवरी 2 वीक्स, एवरी नेक्स्ट 29 को विद पासपोर्ट बुलाया है, fever चल रहा है. So yeah, so Jamin Patel, so I think you are in the same lot where people are buying time. Somebody advised you, or I don't know, a lawyer has done a fever for you. Don't do that. I know you've already done it. That's my advice to anyone listening. So in your situation, you are on immigration bail. That fever is nothing. It's not pending. It may be in that system. It doesn't help you anyway. It will be rejected at some point. That fever is not an immigration application. It doesn't help you with your immigration bail or your Section 3C leave. So my best advice is leave the UK, or if you want to continue living in the UK as an overstayer, from the point they gave you the immigration bail, you have been overstaying. So my best advice is you should leave the UK and file any appropriate application as an entry clearance. You cannot switch to any permission inside the UK, remember that. Other than a permission which would be a genuine relationship, a parental relationship with a British child, or a child who was born in the UK and lived in the UK for 7 years. Quite a hard one, but unless it is genuine, so that is the parent visa is the only one where it is a genuine relationship and all. Other than that, leave the UK and file entry clearance, whatever is your application that you will file in the future. Don't waste your time spending time in the UK on that bail. You are just building up your overstay history. So you may take it or leave it, that's your decision. But I know people don't listen to me, but that is your decision to make. You cannot get sponsorship, you have to leave the UK. Every application for that skilled worker sponsorship or anything that you're thinking of, it has to be outside the UK. You cannot switch being on immigration bail. That is the main reason why Home Office is plugging this. I'm telling this to everyone, people don't listen. I have the other video also. Don't ruin your life in filing these FLR or these fee waivers. Yeah, it's interesting to know that they've started putting people who have filed a few other applications also on immigration bail. Yeah, that is news to me also, but yeah, I think they can do that. So that is my advice for you. While, can my company apply for visa for 2 years and 6 months as a new entrant? Yes, provided you have only spent a maximum of 1 year, 1.5 year on your graduate route, provided. That is the caveat. Yeah, if you want the exact dates, I cannot do date calculations. Aerowhile, if you want the exact dates, what work start date they should put on the application, etc., work end date, you can book a consultation with us. We do it during a consultation. We take all the information when you're filing, what work, job code. We can advise on other matters also, salaries and everything. Yeah, so it's a 30-minute consultation. You get all the answers. But then if you want exact dates, book a consultation with us, and we'll give you the exact dates from when to when the employer can apply. So yeah, so that is my advice. The consultation link booking is description. In the description, you should have the link, or speak to any other immigration lawyer. Okay, next one I have वापस आ सकता हूँ. So another comment from Jamin. You can come provide, you have to assess how long you have overstayed and all of that. If there are any overstay bans, I think if you overstay in the UK for 90 days, more than 90 days, then there would be a 1 year ban. Under that, it should not affect, but they will check on the genuineness of the job. They will interview you. Left, right, center investigation will be done in your case. Remember that any lawyer promising you anything else, they are just lying to you. So let me tell you, Home Office is going to check everything on your case. You have been put on immigration bail. You tried to file in the books of Home Office. You filed some frivolous application, fee waiver and all, just to buy time and all of that. And then they had to actively stop you doing all that and ask you to leave, which is immigration bail. So that's in simple words. So they will be investigating everything. Yes, you can apply if everything is genuine. ERC, and then sponsorship apply. ARC, asylum registration card, is that what you are referring to? No, you wouldn't get Section 3C leave. You are already on bail. Even if you apply for it, that's not going to reactivate your Section 3C or anything like that. That won't help. ARC, what you're talking about. Unlocking UK fees. Okay, the next question I have on the channel is okay, time for some update. Let me give an update. I talked about e-visa, EUSS review. So EU settlement scheme, relationship breakdown, retained rights, etc. I've made several videos on that. So important update from Home Office. They are reviewing any relationship breakdown that has been reported. There is a status review team that will review the situation. They will try to see from your document. This is what Home Office has confirmed. I was just reading, I think 3 days back. Yeah, this is the latest update we have on EUSS status review. Firstly, in case of relationship breakdown, number one, if a relationship breakdown has been reported by the EU national, they will review the status of the partner, whether the person has retained rights. They will also look at the previous application. They will look whatever evidence they have from all applications, and that's how they will decide. If they feel there is no there is retained rights, they are not going to do anything. They'll just make a note on the file and leave it over there. Number one. Number two, if they feel the person doesn't have retained rights, there is no retention of rights, then they would write to the person and give them the opportunity, saying, if you believe you have retained rights, please give us evidence. And in that case, they should give the cohabitation evidence, whatever route they are qualifying on. Let's say they were married to the EU national at least for 3 years. Of that, they've lived in the UK at least for 1 year. So that is the one of the ways to retain rights. There is a child custody. They have a custody of a child. There are about several different areas how you can retain rights, but the main one is the 3 years of marriage plus 1 year of living in the UK, and with cohabitation evidence at least. So yeah, if in that case, this is the update we have. Home Office will be actively reviewing those cases and writing to people if they think that there is no retention of rights in that person's case. On other things, we have also asked them on the status review, which is someone who has pre-settled status, and that person has left the UK for a continuous period of 2 years. By operation of law, the pre-settled status would lapse. Lapse means end, curtail, cancel, simple words. So the pre-settled status would lapse if the person leaves the UK continuously for a period of 2 years. They are saying that they are trying to work on this and they would start doing that subsequently. They haven't started it yet, but yes, this is something that we would see in the future, that they would actively write to individuals and say that we think your pre-sales status lab, please give me evidence that if you think otherwise. So that may start happening. So that is the update aspect. Now let me take some live questions. Owais Ahmed, hi, I'm living in UK since more than 6 years. Can I apply for FLR? More than 6 years. Can I apply for FLR? My visa is about to expire. Yeah, I don't advise applying for FLRs for buying time. Just it is not a buying time application. Sorry. Uh, Aero Wild, thank you for your answer. Can I do work part-time job 20 hours in McDonald's while I'm on a skilled worker visa as IT engineer? I don't think you can do that. The part-time job, the way the 20 hours work is, Home Office has not been beating up people on this. They are not being very strict on this compliances since they are not checking. But at any point they start checking these issues. I know they know that these are the issues. People are working at whatever car washes, delivery driving, or retail sector, or McDonald's or something. Those are not under the skilled occupations for sponsorship. I'm pretty sure you need to find the job code. To the best of my knowledge, it's not on the skilled occupations list of Home Office. You can only do a job which is on that list. So you may not be able to do that job. Any job that you want to do for that 20 hours, Google search for skilled occupations UKVI, look that the job code is there, and only then do that job for that extra 20 hours. Okay, so Kitchen Jen, hi, can I go? What is the question? Can I go private life visa after PSW? Or on, I'm living for 7 years and I have a good earning, but I'm unable to get a sponsorship from my company. My visa is also expiring in a few weeks. So the question is, the person has spent about will have spent 7 years, and he or she, yeah, Kitchen Jen, you are on a graduate route visa. Living 7 years in the UK. Yeah, I think living 7 years in the UK doesn't give you anything. That is for children who are born in the UK. I don't think that would help you. There is not much private life that you have accrued in the UK. Chairman Patel, कि अगर 29 को इमिग्रेशन बिल के लिए बस बुलाए जाऊँ तो क्या कर सकता हूँ? Yeah, they may detain you where they are calling you for the reporting. They wherever the reporting center is, they may detain you. They may allow you to go back. Doesn't matter. If they have decided that they want to detain you, they want to administratively remove you, they want to remove you from the UK, then they may detain you at that point. So yeah, you should do the reporting. uh, if you already leave before that date, that's fine. You can leave the UK before the 29th. I don't know what date are we today. So yeah, so the answer is, if you are not leaving the UK, then go and report. If they try to detain you or whatever they tell you, you can show them the e-ticket, and then they may detain you at that point if they have decided to do that, or they may leave you. Whatever is their decision, they are not going to tell you, obviously. So even if they detain you, worst case scenario, you can give them the e-ticket and then leave. My best advice is, if you are planning to leave before even that date. That's my advice, because they may detain you, and after detention, even if you give them the e-ticket, it takes considerable time to process all of that. You will just stay in detention for a long time if they are intending to detain you. The other possibility is 50% chance they may just ask you to report, and then they may leave you. The vintage tale, can I apply as unmarried dependent cohabitate for 2 years inside UK for skilled worker visa, which is valid for 1 year? Okay. Can I apply unmarried dependent cohabitate? So if you live together with your partner for 2 years inside the UK for skilled worker dependent, you may be able to, but it depends if you have current permission. If you have been overstay, you cannot switch to being a dependent. I don't know what your current permission is. If you have valid permission, only then you can switch to becoming a dependent with the cohabitation. Yes, cohabitation is accepted as a partner relationship. If you don't have any current permission, no, you cannot. Current permission is graduate visa. So you want to switch from graduate to becoming a skilled worker dependent. Yes, 2 years cohabitation. Can I become skilled worker dependent? Yes, you can become a dependent, provided the skilled worker is not sponsored for one of those care worker job codes, and which doesn't allow dependents after 4th of April. So if that is not the case, then yes, you can. So let me take the questions on the channel. Hello, sir. Okay. So no live questions. I go any other country, then this bill can affect. Yes, it may affect you. Other countries, you will have to write down in the most of these ally countries, Canada, US, etc., Australia, New Zealand will definitely have a question asking you why you refused visa or permission or something, and you may have to give all this information. It may affect if they try to see your character, your intentions, whether you're going to overstay in those countries, etc. But yes, it may. I don't do applications for other countries, so I cannot advise you 100%, but there are disclosures on those forms I am aware of. Okay, the next question I have is in the comment section. Hello sir, I started a fixed deposit for 180 days on 28th December. Okay, I'll take this one and then I'll come back to this. 20th December, when can I apply for a visa to show this funds for students? 28th December plus 28 days, that's how I would say. December 2024 plus 28 days. Yeah, I'm using my AI to get some answers. Okay. Okay, so it should be 25th. 28 days. So day one, 25. Yeah. So you can file from 26th of January 2025. So that is my answer. Okay, so your fund should be held at least for 28 days. I think that's the rule you're looking at to meet the financial requirement to file some visa, student visa, yes. So you may have to wait till 25th of January 2025. I don't calculate dates, but I just wanted to help the student. Yeah. Uh, okay, so live question from OS. Is there any way to stay in the UK after PSW? My employer has applied for visa sponsorship. Haven't received any outcome yet. They have promised they'll give me a sponsorship for my visa. Yeah, in such situations, this is a common scenario where either the employer wants to sponsor you. They don't have a sponsor license or they don't have a course, whatever that is. Sponsor license standard processing time is 8 weeks. Course, if they ask for a course, if they already have a license and they ask for a U course, undefined course, it takes 18 weeks for the change of circumstances application to be approved, standard processing. And faster services are almost next to none. It's very difficult to get them also. So in this case, this is what we've done in the past successfully. You can approach an immigration lawyer. It should be done only through an immigration lawyer where your application can be filed latest by the last date of your current permission to protect your Section 3C, and we ask the Home Office to keep the application on hold. The employer has to give some evidence of that, maybe a letter saying we have filed for sponsor license, please give this. You can give the SP or whatever the sponsor license number is. They have get a reference number once they file it, or the submission sheet copy. We tell Home Office this has been filed, please keep this application on hold, we will give you the course in due course. So it is possible whether the sponsor license is pending or a sponsor license is applied, it's already there and UCOS is pending. So pending applications can be filed. Don't file bridging applications. This is what Home Office has told us also. They don't like bridging applications like FLR, EU settlement scheme, fee waiver, and all anything that those agents carve out. So this is what they are not happy about. We've done several of them in your case also, where the person doesn't have a course or even the employer doesn't have a sponsor license. So you file for the license, ask them to keep the skilled worker on hold. Once the license is approved, assign the cost to the person and then assign the cost to the person and then send it to the case working, follow up with them to get a decision on the application. So it is possible. Speak to an immigration lawyer. You can book a consultation with us if you want to do it through us, or go to any other qualified lawyers. That is my suggestion. While we are in skilled worker visa, can we stay outside UK from 2025 June to 26 May? I saw we can stay outside UK 180 days per calendar year since I stay several months into calendar years. So if you want to qualify for the indefinite leave to remain on the basis of skilled worker visa after completing 5 years on the skilled worker visa, and you can include the new entrant category. New entrant is also a skilled worker visa. I know people ask me that. So all your period on the skilled worker visa after completing 5 years, then the rule is that you can be outside the UK for a maximum period of 180 days in any 12-month cycle, not a calendar year. That is not correct if you are thinking of calendar year. It is a 12-month rolling cycle for the whole 5-year period. You can be outside the UK. You are allowed to be up to maximum 180 days. If you are 181, you have broken your continuity of residence, and then you need to restart from the point you come back. So 180 days is the maximum absence allowed on a skilled worker visa to qualify for ILR. 180 days in any 12-month cycle. Sorry, there is no other option to remove the immigration bill. I've given you the answer. I know you will not like it, but yeah, you should leave the UK. It's your decision. Always. Yeah, see, this is how it is triggering. If you file a fewer application, so this is new case, so I'm just sharing on this live only. Jamin, he's live over here. He's telling his own scenario. He filed some fee waiver application. So fee waiver backfiring. Home Office has started it. They are using the ECS check. ECS check, which is, yes, that's a trigger. Interesting. I never thought about it that they can use it. The ECS check is employed. He filed a fee waiver application. Employed did a fee waiver ECS check, employee checking service, to check his right to work. Obviously, he will not get a right to work on a fee waiver. That's not an immigration application. But still, yeah, I know lawyers may be advising that. So obviously, they wanted to reject. They definitely rejected his ECS. It came a negative 100%. I know that. Even if you don't tell me, I know it is a negative check. And at that point, that triggered them to look at his case. They looked at his case saying, his current permission has expired. He's filed a fee waiver. They straight away put him on immigration bill, asking him to give reasons why you want to stay in the UK. That's the standard letter that everyone is getting. I've seen that, Jamin. So, but that's your bad luck. I advise not to file those fee waivers, FLRs. People don't listen. People are still doing it. So, it's your life. You decide. Oh, Simon, how can I book consultation only from you? I want to have phone consultation. Yeah, you can. There should be a link on the description of this video or any other last week's videos. You can, every video should have that. Just click on the, or in the channel information also the links are there. Click on that and yeah, book it. Yeah, it will be through me only. Yeah, so uh, yeah, book the consultation and you can join the video call. You can see me also, or you can join the call and keep your video off. That's your decision. Yeah, but we usually prefer it through the Google Meet. Yeah, so that's fine. It's a 30-minute consultation. All the information is on that link. So Mel B, can we apply ILR after 5 years in skilled worker visa? Yes, you can, provided you meet all other eligibility requirements. You pass the life in the UK test. You are not outside the UK throughout the 5-year period for more than 180 days in any 12-month cycle. What else? No criminal convictions, no issues with the law, etc., etc., etc. So you meet all the eligibility. That's what I mean. Yes, you can apply after completing 5 years. That's what I mean. Next one, what do I have here? Okay, next question on the channel I have. Okay, let me give you another update. I promise every 10-15 minutes, so let me find another update. Where do I have it? Yeah, so pre-settled, I did that one. For settled status and refused. So I'll give the update and take that live question. Okay, so dependency of family members, parents, there is no minimum period. So this is another update or other information sharing. Under the EU settlement scheme, there is an area where family members can join parents. If you are a EU national and you have some EUSS status in the UK, settled status or pre-settled status, your parents who are dependent on you, dependency has to be shown, either financial dependency, emotional dependency, any medical reasons or anything like that. There are several aspects of dependency. uh, and it can be out of choice. It has been held in several cases. This is also information I got from some tribunal case, so I'm just sharing it. Uh, Home Office, when initially that those applications are filed, Home Office may come back asking the period of dependency, saying it's very short, it's only 6 months, the parent has been dependent, or 1 year or something. There is nothing in the rules, in the withdrawal agreement, or in the previous EA regulations 2016 also, or in the youth settlement scheme also. There's nothing in the rules stating that there has to be a minimum period of dependency. Home Office may say that the dependency has been made of convenience. Last 6 months you started sending money and try to do allege all of that, but every case will be assessed on its own merits in a tribunal. Home Office may end up saying, "Oh, it's just a dependency for 6 months. You just created it now. You started sending money because you wanted this application." But all these issues need to be tested in the courts of law. There will be an appeal right, etc. Yes, that point may be valid that the Home Office is alleging, but the only thing that I wanted to update is there is no minimum period of dependency. So it is something that has to be tested in the courts if you want family members joining on the EU settlement scheme and of an EU national only. They don't allow family members of EU nationals to attach family members now. Okay, while do we need to stay on the same sock code until we finish the 5 year? If we change, will the continuity break? No, the continuity will not break, don't worry. So think of it, you need to be on the skilled worker permission for the 5 years. Doesn't matter the job code is changing, doesn't matter. You are changing employers, doesn't matter. All those things don't matter at all. Whether you're a new entrant, you are an experienced worker, that also doesn't matter. Only thing matters is throughout the 5 year period, you had skilled worker permission. Okay, so you can change employer, change job codes, do whatever. In UK, I don't want to leave. I made life hard for me. Scared for upcoming life. Yes, with your girlfriend situation, the only possible option is if you leave the UK and after that you do get married, maybe your girlfriend visits you in the UK. I'm assuming your girlfriend is British citizen to sponsor you, or then your relationship will be assessed, and then your spouse visa will be considered on those merits. Yeah, so whatever speak to an immigration lawyer on the relationship side of things. You can book a consultation with us or any other immigration lawyer, but on the relationship, yes, but you cannot do much at this point. You are on the border of difficult situation. Don't try weird things. Lawyers will take money, they will make all the money, you will lose your life, I can tell you that. So next question. So yes, that was the update, and I'll do the next update after some time. I think I have about 20 more minutes, 15, 20 minutes for this live. Yeah. So, okay, Adil, another live question. Skilled worker visa expires 25th August 25, 2 years. At what time should we apply for the next 3 years extension? Preferably in the last 28 days. You can apply anytime, doesn't matter, but the Home Office will give you from that point forward. So preferably in the last 28 days of your permission. Wild, yes. Thank you very much. Thank you. Anyone who is getting any value in this live, do, yes, you all have already subscribed. I cannot ask for, do give a thumbs up and like this live. Do watch other videos on the channel. I'll continue the live, but yeah, this is the script that I have to say, as all YouTubers do it. So yeah, and there are some paid membership options. You can, if you do get any value, you save costs on your immigration advice, definitely do become a paid member, support the channel. There is just £2 or £3 membership, something nominal that has been built up. Yeah, so yes, second next live question. Mel B, can my daughter be eligible for UK university admission as a British student while we are on ILR? We are on ILR. Will she be considered international student? What is your, what will be your daughter's status? If she has ILR, yes, she will be considered resident, I think so, but I'm not sure what is your daughter's position. Will she be having ILR, or she will be a British citizen, or she will have some permission? It depends what is her current immigration situation. So maybe if for the university to consider as a resident student, Then yeah, what is your daughter's situation? I think your situation doesn't help her. I don't think so. They will do a right to study check on her, to the best of my knowledge. Adil Siddiqui, thank you for the answer. Thank you, Adil. Kitchen Jen, sir, what can be the options if anyone's private life visa is rejected? Can they appeal? How long is the decision time? Private life visa, you will voice file it on human rights. If it is certified, yeah, human rights claim they can certify it, then you cannot appeal. You'll have to go for a judicial review. You may have to leave the UK and then appeal if it's certified. If there are no merits, basically unfounded, if that's what Home Office declares, you may not get an appeal right. It depends on the facts of your case. Yeah, I don't know what your facts were, but what did you say, Kitchenjen? I'm trying to find what you asked me about. Visa after 7 years. Yeah, in your case, I think 7 years in the PSW, you may not even get an appeal right. They may declare it as an unfounded situation, unfounded case. Okay, next question I have is, okay, if we, I'll take this question and give the last three updates that I promised for. My company terminated me after working. What is this? After working. Okay, let me complete the live updates only. So I think there are three updates that. So thank you for staying till the end. Whoever is here till now, I promise that I'll give you several updates. So one of the updates, pending course, that is done. Latest update last week only. Home Office confirmed. I think before that they put it in the guidance. Yeah, employees cannot ability to recoup the costs of the skilled worker visa, how it affects applicants, and how it affects the sponsored job prospects. I'll complete my updates. After that, I will take the live questions. So, because people have been waiting for these updates, several of them. So, any cost that is assigned after 31st December, so as of today, after 31st December 2024, sponsors cannot recoup any part of the cost fees from the employee. So, in the past, so giving a background first, sponsors could recoup the costs except the immigration skills charge. Everything else, sponsors were allowed to recoup. They could also have it an agreement with the employee, etc., and it was fine. Now the Home Office has said sponsors cannot recoup any of the costs. So the cost would be sponsor license costs. Certainly, the sponsor should bear it themselves. They cannot recoup. It will lead to revocation. Any breach on these areas will lead to revocation of the license straight away. Home Office will be quite strict on this. Hence, that is the main reason. There was a lot of abuse. People were buying all these skilled worker visa over the last 2-3 years, along with that care worker situation. People buying, paying them, and companies applying for sponsor licenses just as a business or whatever the frauds were happening. So this is one way to curtail it. They are putting in various measures. This is one of the measures that has been added. Any cost assigned to an individual after 31st December 2024, employer cannot recoup any of these costs, or it leads to revocation of the license. Sponsor license costs, they cannot recoup the cost fees, 239. It is increasing to something like 500. I think yesterday the bill was tabled. It will increase to some amount, 500. I don't have the exact amount, but currently it should be 239. So increasing to that 500 amount. So it is something about 500. I remember that much. I've read that. So it will in maybe next week or so. It may increase once the bill is passed. So they cannot recover the sponsor license fees, no, not the cost fees. They cannot recover the immigration skills charge, which is 364 per year of visa for sponsor. Cannot be recouped. That cannot be taken back, clawed back from the employee. And yeah, so those are all the costs that the employer has to pay: sponsor license fees, cost fees, immigration skills charge. Immigration has the applicant should pay because the health surcharge is for the applicant to access NH. I think skilled worker visa fees, yes, that those. Yeah, we need to see if you want to qualify. So the question is, if you want to qualify for settlement and be eligible for it, you spend 6 months before Home Office and so yes, if you spend more than 180 days outside the UK, it may break the continuity of residence. So, but then if there is a genuine reason, there are several reasons. If you've gone for studies, medical reasons or anything, speak to an immigration lawyer and get assessed all your information, all the absences from the UK, what evidence you have of living in the UK, what evidence you have of living outside the UK, your absences, and take it from there. Yeah, mm, you may be eligible, you may not be eligible, you may have broken it, but get all the information and documentation, at least the information assessed by an immigration lawyer. That's what I can say. If you don't qualify, you may get the automatic extension or so, but all this needs to be take a proper advice. You may get the automatic extension of 2 years or the 4 years, whichever applies. But yeah, in your case, all the information should be assessed properly, whether you are eligible or you're not eligible to file. Your husband as well, both of yours information needs to be assessed. uh, Speak to an immigration lawyer, book a proper advice session, give them all the information, and then take it from there. You can do it with us, the link is in the description, or do it with any other qualified immigration lawyer. If you have broken, then yes, you may not be eligible, but then yeah, all the facts need to be assessed. There are some exceptions. uh, Up to 12 months of absence is allowed for some specific reasons. uh, yeah, so all that can be taken into account. So do book a consultation with an immigration advisor and take it from there. Thank you very much. So I was updating, the update I was giving before I close this call, I think I have one or two, yeah, is the immigration bail position. Everyone, Home Office is putting everyone on immigration bail. So people who are on student visa or any other visa, they're trying fee waiver applications, doing ECS check, they're catching them, putting them on bail. We saw one example on this live only. The person told us that people who file FLRs, etc., they are put on immigration bail. Everyone is being put on immigration bail rather. That would usually, that what does that have any effect on the 10-year long residence if you're planning for? It would ideally break the continuity of residence. Yeah, because you would anyways be asked. So if anyone who is thinking of a 10-year long residence application, think twice before applying these time buying applications, because if you go on bail, there's the end of your 10-year long residence possibilities also. That would break the continuity of residence for the any prospects of 10-year long residence indefinitely to remain. That's mean I have no right for living in the UK. That's means, yeah, I'm not giving you advice on this, Sarah. That's what I'm trying to say. You need to speak to an immigration lawyer, get everything assessed, and only then, yeah, they should advise you appropriately. I'm not saying whether you have a right to stay in the UK or not. I'm not saying that. Can I travel while my visa decision is pending? No, no one can travel outside the UK with a pending application other than an EU settlement scheme application. So you cannot travel outside the UK while your application is pending. Okay, so I'm coming towards the end of the live. Maybe one more update. Yeah, any Ukraine scheme permissions have been taken out from the 10-year long residence. So if anyone who is planning to go for the 10-year long residence, if you have even 1 day of leave on any Ukraine visa schemes, there were several schemes, you have broken the continuity of residence. This is all challengeable in the courts of law, but this is the latest update on the 10-year long residence rules that has been added. Okay, so but this is automatic extension of 5 years. Yeah, the automatic extension of 5 years is for pre-settled status. If you got that, yes, you still have status in the UK to live in the UK. It is not talking of settled status. It only extends pre-settled status. So that is my answer to that one. So Ukraine scheme being taken out, immigration bails will break your 10-year continuity of residence. And those are the updates I have. Other things I need to summarize them and then give them in subsequent lives. So, and let me see, any live question? No. Can take some more. I think I have 10 minutes. 40, 50. Yeah, thank you very much anyone who joined live. I may do this live maybe once in a week or so. I'm not sure, maybe next Sunday, but yeah, I'll update it on the calendar. If you subscribe to the channel, you should get the notifications. and click on the bell icon for the notifications you'll get whenever I schedule it on YouTube. So thank you very much for joining live. No live questions, and this live will be on the channel. You can watch on your own time. If you did get value in this live, do give a thumbs up and like this live. You all have anyway subscribed to the channel, and consider becoming a paid member. It's just nominal 2 or 3 pounds or something. It will give you maybe early access to videos, etc. There are some perks. You can check in the channel information. And yes, thank you very much, and watch other videos on the channel. There's a lot of helpful information on the channel, and everyone has been telling me that. So do watch other videos on the channel, subscribe, get any value from this channel, do like these videos, and consider becoming a supporter of the channel by becoming a paid member, 2 or 3 quid, something, whatever that is. And thank you.